Another episode of the Ahaki podcast. I'm Solomon Serwanja. On this particular series, we focus on litigating sexual reproductive health and rights in Africa, sharing experiences from different African countries, and we've spoken to people from all over the continent. Today, we're privileged to be having Isheanesu Chirisa, who is the Executive Director of Women and the Law in Southern Africa, based in Zimbabwe, Harare. All right, let's get to it. Chirisa, thank you very much for accepting to be with us today.
Thank you for having me.
Great. Zimbabwe, quite a country to look at and focus on in Africa. It's good to hear from you. Let's start off with, describe for us the legal and policy framework around, issues of sexual reproductive health and rights.
Okay, thank you. Probably if I step back and give a perspective of how Zimbabwe as a country is like in terms of values, beliefs and norms. Zimbabwe is a very religious and tradition-driven country in that it shows that the definition of what's wrong and right are generally defined in terms of religion, culture and tradition. So when we're speaking of reproductive health justice or rights, it then means that whatever follows, it's also located within those norms, within the set standards, which are religious.
And culture.
Yes. So the framework of what is right, what is bad, it's mainly fixated in culture and religion. So when we're talking of sexual reproductive health rights, it means that we cannot talk of that from an abstract. What is right, for instance, when we're talking of termination of pregnancy, which is the center of reproductive health rights and justice, it's viewed from a perspective of, is it right? Is it wrong? Is it wrong for you to kill? Is it good enough at cultural level, religious, for you to kill as an individual? And secondly, when we're talking of traditional values, generally women do not have the autonomy over their bodies. You are married into a family, you're supposed then to have decisions made for you within that family that you are married into. So before you think of terminating a pregnancy, you have to consult and get the permission to do so. So it's a larger decision which is done for women by a larger community. So it's really resident within that. But now, coming to the legal, or rather the legislative framework, we have noted that there are several restrictions apart from the religion, apart from the cultural context themselves. Within the legal framework, the starting point is the Constitution of Zimbabwe. We have a fairly recent constitution which was enacted in 2013. We still call it the new constitution. Prior, we had the Lancaster Constitution. So we have celebrated this constitution so much, even as the women movement. It's very elaborate in as far as the human rights framework is concerned. For the first time, rights for women have been clearly elaborated. There's actually a section which provides for elaboration of women's rights, which is celebrated. It also provides for access to reproductive health. It also provides for, yes.
Interesting.
Indeed. It also provides for rights to economic, social, cultural rights in a more defined way. So that's good. When we go now, the Constitution is supported by different pieces of legislation, which gives effect to the framework of the Constitution. Some of the necessary support framework is not yet in place. Why? Because, like I said, this is a new constitution. The realignment process has started. It's still ongoing. In other areas, it has been neglected. So for women to access certain rights that are spelled out in the Constitution, there is need for deliberate re-looking at some of the pieces of legislation, readjusting some pieces of legislation which predates the Constitution. For instance, we talk of the Termination of Pregnancy Act, it's a very archaic piece of legislation. I understand it was enacted around 1977. It criminalizes termination of pregnancy. Termination of pregnancy is only allowed in 2 instances. That is on health medical grounds, where it's believed and certified that continuation of pregnancy would be a risk to the woman who's carrying the pregnancy or to the fetus. And then secondly, on what's termed unlawful sexual intercourse. So the problematic area now is the act is very restrictive.
Was that act
yes
done by the people of Zimbabwe, or it was inherited from the colonial powers?
It was.
Is it part of the penal code? What is it? Is it, did the Zimbabwean people pass it, or was it just inherited?
It was inherited. It's like I said, it's a 1977 act, which it came into act before independence. But we do have what we call criminal law code, which also criminalizes termination of pregnancy by a third person. Like if you really conduct the process of terminating the pregnancy, this is more directly to the health service providers. So it's in support of the 1977 Act. The code is a little bit recent, so it's kind of a reinforcement.
So with these, current, they sound like repressive laws.
Yeah.
How have you been able to do your work as, women who are pushing for a renewal or a review of such laws?
Yeah. As Women and Law in Southern Africa, we work for full realization of women's rights as human rights. When we talk of women's issues, sometimes we think these are just probably abstract things. They are real experiences, and some of them are very sad to not. For instance, we had a client. She was raped by her father in the absence of the mother. In the process, she got pregnant, and she was shoved from one office to the other, trying to have the pregnancy terminated. It was not terminated. There were a number of incompetence that were put between the pregnancy and its termination. Now, sadly, she gave birth to a baby. She's traumatized. She doesn't know how to relate with the baby. Neither is the mother able to comprehend, the outcome of this sexual violence. So if the law was more permissive, if the law was more adaptable and living to the real experiences of what women are going through within the spaces of, be it private sectors, public spheres, we wouldn't be talking of such a sad situation. But the issue is that the law as it is today, it's very restrictive. Sometimes, for instance, in Zimbabwe, we have recently criminalized child marriages. There is criminalization of child marriage. A child is somebody below the age of 18. But the irony of it then is, what if somebody else has sexual intercourse within that kind of arrangement? They conceive. The law does not allow for the termination of that pregnancy. So it means you may not get married. Assume there could have been an arrangement of that marriage between two people who are below 18, they will be penalized, but they don't want to terminate the pregnancy. Some of the children, some of the young girls are then compelled to carry through such pregnancies, and it's quite traumatic. And as Women and Law in Southern Africa, we have been going before the law, seeking for what we call reforms of the law through strategic impact litigation. We mounted a constitutional challenge saying that the provisions of the Termination of Pregnancy Act they contravene the constitutional provisions in that they take away the rights that are already enshrined in the Constitution. We were seeking to challenge Section 2 of the Termination of Pregnancy Act. Section 2 defines what is unlawful sexual intercourse. It only defines unlawful sexual intercourse in as far as rape is concerned. It doesn't contemplate rape that is located in a marital setup. Neither does it contemplate that sexual intercourse that takes place between either two young people, a girl and a boy, or even an adult with a young girl. It doesn't. As a result, you then find a girl has sexual intercourse, never mind their ability to consent to that, and then they fall pregnant. You then approach the medical services for termination. The law doesn't allow. Why? Because the manner in which the law is positioned, just as I explained here earlier on, it's wrong, it's a sin, etc., etc. So even within the systems that are supposed to be protecting these rights, we have been facing challenges. The reason why we have mounted a strategic impact case. Currently, the case has been heard. Unfortunately, we haven't received our judgment. It is our hope that probably through this type of litigation, we will be able to influence and to an extent, maybe push for a very sustainable piece of legislation in as far as the rights of women and girls are concerned in accessible health rights, especially terminating unwanted pregnancies.
Okay. Are you optimistic about this public interest litigation case?
Yeah, well, it's 50-50. It's 50-50. But the good thing then is we have also been, over and above strategic impact litigation, we have also been doing what we call human interest cases. These are real cases where girls then given an opportunity to share their experiences, what the journey has been like. Maybe they were raped within a family setup, and often where there is sexual violence within the family, it's difficult to report. It's even difficult to have the pregnancy terminated. So we then allow and create an opportunity for girls to talk about this. Why we do so, it's a way of persuading even some of these traditionalists, some of these, gatekeepers in as far as religion is concerned, to say that it's not because we want to commit sin or we want to kill, but these are real experiences. Once a child becomes pregnant, the childhood is taken away and it can never be given back. So we want the law that's very permissive. We hope, maybe it will come through, but strategic impact litigation in Zimbabwe has its own challenges, especially around economic, social, cultural rights. It also means that you're creating certain obligations, resource-wise, for the state. In terms of our constitution, they say these are not immediately justifiable. You then realize them at what they call progressive realization, meaning that as and when the resources become available. So you can really litigate and get a successful or a positive judgment. They will tell you that at the moment, resources are not yet available. Once we do have them, we will progressively make it given to whoever is claiming that right.
Okay. When you are litigating these cases, what do you read in the room for the people in the robes? I mean, the judges. Are they objective in listening to these cases? Or do they come also robed in culture and religion, like you mentioned? Do you feel that there's openness towards discussing and presenting real cases and evidence to the courts, and they listen to them?
Yeah, well, we do have judges who are very progressive. For instance, in Zimbabwe, we have had a very celebrated landmark ruling which pronounced the illegality of child marriages. So sometimes, yes, we do have progressive judgments, but generally, not necessarily that you're litigating reproductive justice. Strategic impact litigation in Zimbabwe, it's a phenomenon which is still very much under development. Even as you approach the courts, sometimes there's a lot of skepticism. It takes very long. Sometimes our courts are very technical, like you really need to understand the constitution, you really need to know your procedure, you really need to put your issues on your fingertips. Otherwise, before you even have your matter heard on merits, it's dismissed on technicalities. Even before I joined WLSA, I was working elsewhere within the litigation department, focusing mainly on what we call public interest litigation, strategic impact litigation. And this is a kind of specialized type of litigation where you seeking to push reform beyond the immediate litigant. So when you're doing that, this is not just small intervention, it's big. And often within the court itself, there are a lot of skepticism. Sometimes you get your case heard, you don't immediately get the ruling or the judgments delivered as and when you would want them. They take fairly long, and also the skill, it's not immediately or rather widely available. So I would say that the experience, it's a mixed bag. Yeah, it is a mixed bag. And sadly, in as much as we have a new constitution, like I said, which has a very expansive Bill of Rights, the jurisprudence to test and give effect to the advantages which are enshrined in that bill hasn't been tested. So our jurisprudence is still very much developed, such that in as far as economic, social, cultural rights, we are having to rely more on South African cases. In Zimbabwe, we don't have a lot of case authority around economic, social, cultural rights, where reproductive health rights is located.
Yeah, and that's a very big challenge when you're litigating such cases.
Yes, it is.
You have to get, authorities from South Africa, stretch it to East Africa, try to look at, it becomes very difficult. How does this law that you've described to us and the challenges of doing strategic litigation, how does it impact on access to sexual reproductive health and rights services for women in Zimbabwe?
So, as I said, the Constitution is 2013. It's giving such rights. But when we're talking of rights, or what they call the typology of rights, there are rights holders and there are duty bearers. So when you're talking of the duty bearers, it then suggests that the state has constitutional obligations which they ought to give to its citizens, like they should protect, promote, and fulfill the rights that are contained therein. So in Zimbabwe, we do have a good constitution. But now, between the constitution and the realization of such rights, there is a big gap. So when you then try to close the gap, you do so through litigation. So when the litigation space is also constricted, restrictive, it then means that we may have a good constitution, but in as far as implementation, reality, lived realities for people to enjoy reproductive justice, sexual reproductive health rights, it remains a pipeline dream. Especially for a lot of women, we're talking of maybe access to healthy care, access to safe and accessible termination of pregnancy services. You're talking of other general sexual reproductive, medical or health-related care. It remains then a pipeline dream. So in as far as rights pertaining to reproductive justice, sexual reproductive health rights, I think we're still far away from realizing them as women in Zimbabwe.
What does the future look like for litigating issues around sexual reproductive health and rights in Zimbabwe amidst all the challenges you've shared?
Yeah.
Do you have hope?
Yeah, of course. I mean, like lawyers will always be there, and we really have to remain with relevance, not because we have to litigate because we want to find relevance, but I think our relevance is found in giving effect the benefits of the law to the people. Like we translate the rights to the people through litigating sometimes, of course, sometimes through advocacy work. So I think, indeed, there is hope. It's not all gloomy. 2 years back, WLSA litigated successfully a case where they sued the Minister of Health. And in that case, we were awarded damages on behalf of the client, where there was negligence in one of the hospitals in Zimbabwe. The woman lost a baby because of medical negligence and disregard of professional duties and etiquette, and the baby died in the process. We sued the Minister of Health, and damages were awarded. We think that sometimes, just as I said, we do have the opportunity and chance to make the difference. So it's not all gloomy. Mm-hmm. Yeah, it's possible.
There's hope.
Yes, indeed, there is.
Thank you very much. Isheanesu Chirisa, thank you.
Thank you for having me.
Wow. I've been speaking with Isheanesu Chirisa, who is the Executive Director of the Women and the Law in Southern Africa, located in Zimbabwe. The great work that they're doing there, as she said, that there's still hope. Thank you so much for being part of the Ahaki podcast. Catch you next time.